We've done lecture 1, 2, 3, 4, 5, and 6. This is lecture 7, and I welcome you. As I said, the book guides our discussion in this lecture series. I want to quickly go to where we stopped yesterday, which is chapter 2. Yesterday we discussed control in when you are applying or using amicable dispute resolution. When you are using an amicable dispute resolution process, how the parties own the process, how they control the process, particularly the outcome. The outcome, they determine the outcome of the process. Unlike what happens in court and at arbitration, where a third party determines the outcome of your dispute resolution process. So we're talking about features of mediation, and the first feature we discussed was control. So let's move on to another feature. It's flexibility. I'll read it and then we'll discuss. A unique feature of mediation is its flexibility. There are no set rules or binding laws except for those agreed by the parties, always with a view to reach an acceptable solution. I repeat, a unique feature of mediation is its flexibility. There are no set rules or binding laws except for those agreed on or agreed to by the parties, always with a view to reach an acceptable solution. So you can see it's tied to the first feature of control. We can be flexible in mediation, in conciliation, non-amicable dispute resolution process, also known as alternative dispute resolution ADR. We can be flexible because we have control as parties to the dispute. And that's very important. The flexibility allows us to set rules and probably apply laws that will help us, that would smoothen, facilitate, aid the dispute resolution process, or the laws and rules that we agreed to as parties, we agreed to use in our amicable dispute resolution process. They are not ends, those laws and rules are not ends in themselves. They only aid the process, or the process, assist us to reach an acceptable solution, acceptable to the parties. So that means you know a good mediator, a good negotiator by his or her, by their flexibility. We'll discuss this again in chapter 10, when we're looking at the forum for effective conflict resolution. This will come up again. The next feature I want to discuss right now, or put before you, is parties' input. I read, agreements reached at mediation always resolve from the parties themselves, and are not imposed from above, unlike what obtains in litigation and arbitration, where the judge and arbitrator bind the parties to a judgment or an award, the content of which judgment or award is largely at the discretion of the judge or arbitrator. So let's try to understand what we are discussing here. Parties input. When you resolve your disputes with the skills we are discussing here in this lecture series, what you end up with is an agreement. So it's not imposed. It's imposed only to the extent to which you impose it on yourself, not that the third party imposes it on you. You are saying this is how we want to live our life in future. So you are your own judge. You are your own arbitrator. You bind yourself by yourself. I'll touch on this later, because even though it's an agreement, you have to know that once you agree, it binds you. It binds you. As soon as and as long as you agree, you could also additionally decide that you want it to be a consent award or a consent judgment. So you will look on the face like a judgment or an award, but it's actually a settlement. It's actually your agreement that you take to the judge to say, well, I want you to reduce this, or we want you to reduce it rather to a judgment, as if it's a judgment of the court. I will explain why this might be done later when we're talking about enforcement of a mediated agreement. The same thing with an award, a consent award. Let's move on. Another feature of mediation or effective conflict resolution is speed. Let's read. A further feature of mediation is speed of resolution. Speed of resolution. I was a party's counsel in a mediation that took precisely 1 hour, 15 minutes. 1 hour, 15 minutes. And we reached an agreement. If the parties to this conflict had sought to resolve it in an adversarial way, i.e. via the court system, the conflict would have taken years to end. There would, for example, have been pleadings to file, maybe applications and discoveries to be made. These are judicial litigation terminologies. Even after a decision, after the judgment, an appeal by either party would have prolonged the conflict resolution by some years, by which time parties would have probably spent more than the value of the dispute. In some places, children inherit their parents' litigation. So when it's amicable, it closes faster. That's what we're saying. Speed of resolution. Because you cut out a lot of things. No grandstanding, no brinkmanship, no traps. Because it's not about who wins, who loses. It's about how do we resolve this conflict that is impeding our ability to live a more meaningful life, a more prosperous business relationship, a more enjoyable, happier family, marriage. That's the focus. Not about deciding who is right, who is wrong, and doing everything to be, after determining that you are right, doing everything to be right. Or after determining that, after you're determining I'm wrong, do everything to show that I'm wrong. No. It's not the focus. It's not the focus. And that's why I give the example of that case that I was part of as a lawyer in maybe 10, 15 years ago. Sorry, more than that, probably 20 years ago, about 1999. So about 21 years ago. And so we spent, after 1 hour, 15 minutes, we reached an agreement. And I wasn't the mediator. We had a mediator. I was just representing a party. I was a party counsel. And I know that it would have lasted long because I'm also a lawyer. I mean, been going to court off and on for 32 years. So I know the same conflict that we're able to resolve in 1 hour, 15 minutes. That's 75 minutes, right? That's 75 minutes. We could have spent years, filing all manner of papers, trying to do everything to win. Because the focus in conflict resolution is different. The focus is how can we holistically, what's the fastest way to deal with the problem before us. So that's speed. I think we can look at that one more feature before we close for today. The feature of cost saving. Again, let me read. Concomitant to the speed of resolution is cost saving. In the foregoing example, our clients saved money by the use of mediation. The fact that I had some skill in mediation helped, as I was able to appreciate what had to be done and to assist our mediator to do his work speedily. But even if I wasn't a mediator, even if I were not a mediator, I think we would have, I'm sure, I'm positive, I'm 100% sure that we would have closed faster. Of course, if our mediator knew his job or her job. Maybe because I'm also a mediator, I'm able to help get a quicker resolution. So it took 1 hour, 15 minutes, maybe it would have taken a day. But compare a day to 3, 4, 5 years or 10 years, or to inheriting or passing on the litigation to your children, your kids. I'm probably forgetting why you started the conflict in the first place. And spending money that you don't need to spend, Let's continue reading. Still on cost saving, mediators' fees are relatively modest. Mediators are, of course, able to minimize parties' costs because the process that they offer is at once quick and amicable. Once you extract antagonism from conflict resolution, settlement is almost in sight. And when parties settle quickly, they reduce their costs. So it's really commonsensical. This feature of cost is really commonsensical. When it's not about losers and winners, victors and losers, right and wrong, you're able to focus on what really is the problem and then get to its roots and resolve it and move on with our relationship. Of course, it simply means we spend less than if we were fighting to finish. I think we can stop here for today. We'll continue tomorrow in lecture 8. Please remember to post your comments, your critiques, your suggestions, recommendations. And as I said yesterday, you can order the book, How to Resolve a Conflict, which is our textbook for this lecture series. You can order it. It's easily available on Amazon. You can get a free copy if you have Kindle. You can buy a soft copy if you don't have a Kindle. And you can buy a hard copy. They are all available there. Thank you for joining me, and I look forward to seeing you tomorrow.